Be cool, be kind, be classy. The cupcake's so sweet and sexy. Have fun, enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives in New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Meshegas. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcake's sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Where am I? Hi. Hello. Sorry I'm late. I was rushing. I saw a little cupcake defending me like, she must be having technical difficulties. But no, I was just rushing because it was a last minute thing that I decided to do today. And I was actually prepping for you. I was prepping for you because so many of you have been asking me, when are you going to do this? When are you going to do that? When are you going to do this? When are you going to do that? And I've been so invested in Edrick Faust's acquittal that I just can't focus on anything else. I'm single thread, as you know. Thank you for all the birthday wishes. How did you guys know? It's not like I have a Wikipedia page or anything. Me and Abe Lincoln. Don't forget what banner. Oh, the banner that's up right now. That's not supposed to be. Well, yeah, that was yesterday when the state rested in the Faust trial. And I don't know where it is on my thing, so hang on. There's no court today in the Faust trial, and I don't know for sure, but it may be because yesterday at the end of day, our new king, attorney Ahmad Cruz, announced to the court and everyone that his wife had been rushed to the hospital. And so there's no court today on the Edrick Faust case. It will resume tomorrow at 9 a.m. and we will resume tomorrow at 9 a.m. No, there's no court today. It has been called off for the day. So prayers up for Mrs. Cruz. Do not dox her if you happen to have found out who she is. We're not doing that here because this trial, as if any trial, all the trials bring out the crazies, but this trial has brought out a lot of crazies. A lot of crazies that are coming for not just me, other people that you might know from the interwebs. And the judge even announced it in open court yesterday. It was wild. Like she's telling the jury pool, not the jury pool. The judge in the Faust trial, Lisa Lott, has announced to the gallery at the trial that it has come to her attention that there are people online talking about the jurors, not naming them, not describing them physically, but talking about their facial expressions, whether or not they're taking notes, whether or not they're paying attention. And she claims that under Rule 22 of the Georgia Superior Court rules, that is not allowed. And I call, what do you think I call on that way? Where's my button? We read Rule 22 together. Rule 22 in Georgia is all about recording court proceedings. Has nothing to do with whether or not the media are allowed to talk about the jurors. Okay. So this is going to be interesting. She wasn't talking about me, as far as I know. I think I know who she was talking about, But it's they don't want the world to see what's going on. Maybe she's taking a beating on socials. I don't know. People are sending me all kinds of wild stuff. Chris Melton is going to sue me for defamation. Really? Chris Melton's going to sue me for defamation? Oh, that's interesting. Maybe he should sue the state of Georgia for defamation for bringing him into this trial. But, you know, I mean, trolls be trolling. That's all they're going to do. Trolls be trolling. Today's a great day to catch up on this trial if you have not been following it with us. We are watching a modern day in real life To Kill a Mockingbird that Harper Lee could not even have scripted better than what we are worse than what we're watching in real time. It's insane. But we're not here to talk about that specifically today. Today, we're specifically here to talk about a lot of other things that we have not been able to talk about since the Faust trial started. We just sort of fell into it on a week ago, Monday. I saw it was starting on Long Crime. I was like, oh, we need a new trial. Let's get a new trial. I read a little bit about it. I thought it would be interesting because it's a cold case. And so I thought, let's see, you know, what it would be like to try a cold case, what kind of evidence they could have against this man 25 years later. He was never a suspect in the case ever at all until 2024. It's wild. It is a black man who is being railroaded, in my opinion, in a Georgia courtroom. And in my opinion, the judge and the prosecution are letting it happen in real time. It is wild. There was never even a black suspect in this case. It involves, for those of you who don't know, the 2001 murder of a beautiful young law student, 23 years old, by the name of Tara Baker. She was brutally murdered in her Athens, Georgia home, where she lived with two roommates who were also in graduate school. She was in law school at UGA at the time. It was the evening of her 24th birthday. She was raped both ways, or sodomized both ways, I should say. Beaten, strangled with a power cord from her printer, stabbed, and then her house was set on fire and deadbolted. The doors were deadbolted. Her boyfriend had been a suspect in the case. Well, really, maybe not. Maybe he was never a suspect because he had the trust me, bro alibi, and boy, did they trust him, bro. A couple of people saw a black man walking around the neighborhood. They came in to testify. But nobody specifically pointed to Edrick Faust, who's sitting in the defendant's chair, and said that it was him. And then 24 years later, they decided to retest some DNA because they had some DNA that had 3 contributors on the body of Tara Baker. The third contributor had never been identified until 2024, when they decided to run it through CODIS. And all of you who follow true crime know what CODIS is. CODIS is a national database run by, I think it's the FBI. And it depends on what state you live in. In certain states, you must be a convicted felon for your DNA to be admitted into CODIS, or submitted into CODIS, or put into CODIS. In some states, an arrest is enough, I think, to put you into CODIS. It was a crime of passion and very personal, says Lauren. This is not the crime by a stranger to her. But when they ran that DNA through CODIS, allegedly, they got a hit on the defendant, Edrick Faust, who had been in the system for other things, including maybe in possession with intent to distribute. We'll just call it yayo, because you guys told me about yayo and I didn't know what that was. And you guys told me. So, you know, nose candy. And he had been in a bar fight with a guy right like 2 weeks after Tara Baker's murder, in which a knife was involved. So look, if you're going to pin it on the black guy, maybe pin it on the black guy who might have had an address at the time that he gave as his permanent address that was 585 feet away from Tara Baker, and who may have been involved in an incident involving a knife. And this judge has allowed them to talk about CODIS because she said, oh, the jurors aren't going to know about CODIS. They're not going to know that it's mostly, convicted felons in CODIS. And it's wild. The initial run in CODIS did not generate a report because the defendant's DNA was not in CODIS at the time. And I don't even know if they ran it through CODIS in 2001. I don't know, because they really aren't clear on so much in this case. And it's all confusing. It's all confusing, but I can't explain any more of that to you today. You need to come and watch the trial. You need to catch up on the trial because you don't want to miss this. The defense case will be starting tomorrow if they choose to put on a case. We're not really sure what's going to happen yet. If they call very few witnesses, we could see closings tomorrow, and we could see the jury get the case by end of day tomorrow. Tomorrow's Friday. So we will see. This judge likes to work. She likes to work until 5, 6. Some days she's been there till 6:30. Because initially when they started picking the jury on this case, they told the jury it was going to be a 2-week trial. And then the prosecution said, oh, no. By the way, we have 80 witnesses and we think it's going to be 4 to 6 weeks. And the judge was like, hell to the no, it's not. And the state rested yesterday. And in my opinion, they have not proven beyond a reasonable doubt that Edrick Faust was even ever in that house at all. But they want the jury to believe that there's no way in hell that a beautiful 23-year-old white girl would ever have consensual sex, perhaps with an also 23 or 24-year-old very attractive black man. That's still alive and well in Georgia, and it's wild. It's wild. All right, you guys watching the Olympics? I got my Team USA shirt on today. Go Team USA. I did watch the ice dancing last night. The Americans did not win. They were not happy about it. Madison Chalk and her husband beat out by the French couple who I thought they've only... See, the thing is, the ice dancing French couple has only been together for a year. I don't even know if they're a couple. I'm just saying pair. And Madison Chalk and her husband, I forget his name, Evan, I think, have been together for 15 years. And so it was a little bittersweet for them. They're like beaten out for the gold by a team that's only been together for a year. But I got to say, they were beautiful. The French team was just beautiful. I was watching earlier today, men's hockey, Canada versus Czechoslovakia. And Scott, I don't know if you're here, but one of the Islanders is playing on the Canadian hockey team. So there's that. And the women's hockey team is doing pretty great too. Oh, please. So it's fun. It's fun. Let's see. What should we talk about first? Parachuting matron saint of Karen Reed. Oh, you got your name from Dr. Marie Russell. It's been here for 11 months. Happy birthday. Hope you have a fab day. Thank you so very much. And thank you, Bamber, for being here for 4 months. Thank you. I appreciate all of your birthday wishes. And USMC Cowgirl, thank you for your service. Your youngest is 18 today. What a great birthday. And she's Aquarius too. Happy 18th to your girl. I love that. Hey, Faye, happy birthday to us. It's your birthday too, Faye. Oh, hey, Faye, happy birthday to us. We're birthday twins. Yay. So happy to be a cupcake. Thank you. Thank you. And Christy became a member. Renee became a member. You guys are awesome. And all of you are awesome. And Team Brittany says, don't mess with French couples. What are my thoughts to lots? Wait, my StreamYard is really having issues. But what are my thoughts on Lot's response to the directed verdict motion? I never thought she would grant it in a million years. I don't remember the last time a directed verdict motion in a criminal trial was granted. If you can think of one, let me know. It is always made. It is rarely granted. I didn't see any evidence of a burglary. I didn't, but I guess, the back window that's missing. I never thought she would grant it in a million years. We've seen the pretrial rulings, many of them, Sally Joe, the drama, and we have, seen the way that this judge has been ruling against the defense almost every single time. I think she may have sustained maybe one or two of Ahmad Cruz's objections. Maybe. A lot of Aquarius in the chat. Aquarius is amazing. And I'm just thinking the whole time, I'm thinking if I was in that courtroom, I would be like getting handcuffed like Brian Steele. Like I would not have been able to control myself. I wouldn't have. Thank you for asking. He has appealed, however, Ahmad Cruz has appealed the sanctions. And so we'll go over those papers on another stream because today we got to get back into Massachusetts. We want to talk about Jesse Butler. There's going to be a hearing coming up on that. And I have a whole agenda. I have a whole agenda because, you know, I felt bad that we weren't getting to a lot of things that you guys wanted to talk about. So let us pull our affirmation for a badass today. We're getting low on this deck of cards, but I've got another deck, so don't worry about that. And here we go. Oh my gosh, this is so perfect for today. You saw me pick it. It was random, right? It says, and it usually doesn't say things like this in this deck. It says some people are really sick, so avoid them. Some people are really sick, so avoid them. Oh, there's a few I can think of off the top of my head. In fact, I was talking about a couple of them this morning. Wild what's going on out there. Chris Draper says they're trying to kick my friend infamous Sylvia out. They took the passes so they could see names and their social media to watch comments. She was great in YSL trial. Is there anything that can be done? We're working on it, Chris. We're working on it. Thank you for that. Some people are really sick, so avoid them. I mean, I can't even believe it. Yeah, that person who wrote me an email yesterday that people say is Chris Albert. That person who said she reported me to the court. She reported me to Judge Lisa Lott. Some people are really sick, so avoid them. That's all I can say. Some people are out there on social media attacking children. I can't even. Who does that? I don't know. You might know. We're not going to talk about it, but that's a great affirmation card. Avoid the sick people. Keep your circle small. Don't let people in. Don't trust anybody. Well, I don't trust anybody. Anyway. And just not everybody deserves the seat at your table, okay? Not everybody deserves a seat at your table. Just the way it is. It's the truth. Right? But if it is Chris Albert who's trolling me, it just seems so perfect. Just so perfect, so obvious. I mean, can you believe that this guy is an elected public official? Really? And this is what he does out there? Wow. Okay. Your time is going to come. Just remember that too. I think in song lyrics, as do many of you. All right. Let us first, we are going to go to Kelsey Fitzsimmons. We're going to go to Kelsey Fitzsimmons because that happened just this week. A lot of stuff happened this week. Kelsey Fitzsimmons on, I believe it was Monday or Sunday night. What day was the motion to recuse Judge McCarthy Neyman filed? It was filed on, I think it was filed on Monday morning, February 8th. So today's the 12th. So I guess it would have been filed on Monday morning if it's dated on the 8th. Okay. Let's take a quick look. We're not going to read it word for word, but because of the results, which are also good. So let's take a look. For those of you who are not aware of the case of Kelsey Fitzsimmons, I didn't get a chance to do my show notes yet, but I will. Kelsey Fitzsimmons is a North Andover police officer. She was engaged to a guy named Justin Alayan, who is a North Andover, Massachusetts firefighter. On June 28th, 2025, this just was. The couple went to celebrate her bachelorette party somewhere in Maine. Some things that are disputed may have happened at the bachelor party. Justin and Kelsey got in a fight. They have a baby together. The baby was born I believe in February. I think the baby's turning 1, right? They were scheduled to be married in October. So something happened over the weekend in Maine that prompted Justin, and they lived together in Kelsey's house in North Andover. She owned it on her own. They lived there together with their baby. Something happened. Whatever it is that happened prompted Justin to go into court on Monday morning and get a restraining order against Kelsey and make some allegations to convince the court that the baby should be taken away from Kelsey. And this was all done ex parte. And we've been over the papers. We have a whole playlist on the Kelsey Fitzsimmons case. Later that afternoon, it was June 30th, 2025. Kelsey is feeding her baby on the couch. She's still breastfeeding her baby boy at that time. She's in her 20s. And there's a knock on the door. Some footage has recently come out from inside Kelsey's home of exactly what happened when she answered the door. She's got her baby over her shoulder, like burping him. She comes to the door, and lo and behold, there are 3 male North Andover police officers there, her co-workers. First one in is waving a piece of paper around because there's no audio. But we know that the paper was the restraining order that Justin obtained ex parte and in order to take the baby away. Officer number 2 who walks in has gloves on. His name is Officer Neyman. Put a pin in that. And then there's a third officer who comes in. And they're like, hey, Kels, hey, here's a restraining order. Justin has a restraining order against you. And by the way, here's another order. We're here to take the baby away. And by the way, Justin's going to be here in a couple minutes to pick the baby up. Justin had asked Kelsey to meet him at a park so they could talk with the baby. She went there. She waited for something like 2 hours and he never showed up. The male officers did not show up with a mental. Oh, and it's important to know Kelsey had also been out on leave from the police department because she had postpartum depression. She was receiving treatment for her postpartum depression. Justin knew it, and he was real supportive of her and her journey. She had just been cleared to return to work on July 4th. And remember, this was June 30th. And she had just received her guns and badge back. Noonan's story differs from Kelsey's story. And so, you know what I say, there's always 3 sides, at least 3 sides to every story, right? Your side, my side, and the truth. Noonan from Caddyshack, yeah, Noonan. So they take the baby. They call Justin, who I guess maybe he's waiting around the corner, and they're like, Justin, you can come over and get the baby. Justin is, I guess, in the basement or somewhere on the first floor of this home, collecting some things from the baby. Kelsey says, can I go upstairs and pack some things for the baby? This is all summarized because we don't really know what happened. Kelsey goes upstairs to the master bedroom to pack some things for the baby. Noonan comes with. One of them stays with Justin, one of the other officers, and another one stays on the first floor. They go upstairs, and what happens next is an issue because North Andover PD does not wear body cams. They know what they're walking into because they know that Kelsey's suffering from postpartum. And in fact, in the papers that Justin filed, he said, you know, I'm afraid that when you go to serve this restraining order, she may try and do something to the baby or herself. So they're on notice of what they're walking into, right? Potentially. They're in the master bedroom. Kelsey, according to Noonan, ducks behind the bedroom door, jumps out with her firearm and points it at Noonan. And in response to Kelsey pointing the firearm at Noonan, Noonan pulls out his firearm and shoots Kelsey in the chest. Kelsey says, number one, there's no door in my bedroom at all. There's no door and there's no closet door. There isn't even a bedroom door. She says she wanted to take her own life and that she pulled out her weapon and pointed it at herself. And then Noonan shot her in the chest at like point blank range. She is airlifted to, I think, Boston General Hospital, where she undergoes 5 surgeries, clinging to life, collapsed lung, lacerated liver, I believe. Don't hold me to the injuries, but terrible, terrible, like life-threatening injuries. The officer on the first floor hears Noonan say, "Kelsey, don't do it. Kelsey, don't do it." While Kelsey's in the hospital clinging to life, Kelsey is arrested for attempted murder, assault with a deadly weapon, and I forget the third charge. Noonan is not charged with anything. The case goes to a grand jury, and the grand jury does not return a true bill on the attempted murder charge. They only return a true bill on the assault charge. And under Massachusetts law, and because of Kelsey's history, she would be entitled to probation, no jail time, under the guidelines for this alleged assault charge. Now, it has been said famously many times that a grand jury, a good prosecutor can get a grand jury to indict a ham sandwich. The fact that the grand jury did not indict on the attempted murder charge tells you much of the things that you need to know. Kelsey, after she's discharged from the hospital, is sent to jail. Her attorney, Tim Bradl, who also famously represents AIDAN KEARNEY, aka Turtleboy, and in addition to many other high-profile defendants in Massachusetts, argues for bail. The judge agrees to let Kelsey out on bail, but she has to run criminal background checks on everyone in the house. I think one of the people is forced to move out of the house, and she is then released to the custody of her mother and stepfather, with the condition that she blow into a handheld scram monitor device to test for alcohol. Remember, she has a collapsed lung. She's undergone 5 surgeries. And it's probably and fractured ribs. After, the judge says, okay, I'll give it to you, but I got to run criminal checks on everybody. The criminal checks and everything else take about 10 days. So from the day that Kelsey was granted ROR, it took a while for her to be able to be released to her mother and her stepfather, but she was finally. And then Tim Bradl said, Your Honor, I understand you want an ankle monitor on her. Oh, also a GPS monitor. You want an ankle monitor on her and also this separate alcohol testing. But here's the thing, Judge, she's supposed to have surgery tomorrow. Would it be okay if we have the ankle monitor? We'll come right after the surgery to probation to have them install the ankle monitor because we don't think that the doctor is going to do surgery with an ankle monitor on. Those of you in the chat who work in healthcare, I know there are a lot of you know, or anyone who's ever had an operation, you know that you have to take all your jewelry off during an operation. You think any doctor's going to operate on anybody with an ankle monitor? I don't know. I didn't think so. The judge was like, no, you can't do that. So Kelsey had to postpone that surgery. Okay. 48 hours later, Mr. Bradl files an emergency motion to the court and says, Your Honor, here's the thing. Kelsey, because of her injuries and her recuperation, is not able to, she's able to blow into this device, but the thing is that she can't do it without having hours of pain afterwards. So would it be possible that we could do another method of alcohol testing? She's not saying she won't alcohol test, but maybe we could have her do the P test, where they either come to the house and do the P test, or she goes to the place and do the P test. And there is a very contentious hearing. We listened to the audio of it. Judge Kathleen McCarthy Neyman, who's the judge for all of these proceedings, says, because Timothy Bradl says, as part of his argument, Your Honor, this would be cruel and unusual punishment for Kelsey to continue to have to breathe into this thing because it's very, very painful for her. And there are less restrictive methods. Remember also, alcohol had nothing to do with what happened on June 30th with Officer Patrick Noonan. But the judge just trusted some people who said Kelsey might have a problem with alcohol and maybe she got drunk at her bachelorette party and had a fight with Justin. We're not really sure because Kelsey was not part of those proceedings, but we did read the papers on them. Judge said, cruel and unusual, you say? Well, I wouldn't want her to have any cruel and unusual punishment. So back to jail she goes and put her back in jail. The Commonwealth of Massachusetts didn't even ask for her to be put back in jail. And there was a probation officer who testified at that hearing. His name is Jeff January. And he said, Your Honor, I saw her do it. She's in a lot of pain. There are other ways we can do this. And so she didn't care. She threw her back in jail. This is in Salem, Massachusetts, Essex County. Because Kelsey, before she was a police officer in North Andover, I forgot to tell you she was a corrections officer. Because of those two things, they decide they have to put her all the way in Chicopee Women's Prison because she needs better protection, being a police officer and a former corrections officer. And there's a lot more to this story than I'm telling you. I'm just trying to summarize it. An appeal drags on because Kathleen McCarthy Neyman, the judge, has shown her true colors. Timothy Bradl at some point has Martha Coakley, the former Attorney General of Massachusetts, come in and, oh man, I need my roots done, come in and join the defense team, which she does. And this goes to the one judge panel at the appellate court who's like, yeah, no, the judge did not exceed her authority. She's got wide discretion and she's able to do whatever she wants. It then went up higher to the appellate court where it was denied again, went to the highest court in Massachusetts, the SJC. Then another judge comes in who had said during one of the hearings, Mr. Bradl, if you make this motion again and her circumstances have changed and she can now blow into the thing, maybe I could let her out. They also violated the Americans with Disabilities Act. That was part of the argument that went to the SJC. I did not agree with the SJC ruling on this, but nobody asked me. You asked me, but they didn't ask me. Finally, Kelsey is let out of jail, but I think she was held there for how long, you guys? Like another 90 days? Missing all of her baby's milestones. She is allowed to have zero contact with her child. She has not seen her child since June 30th. And this whole thing is an abomination. And so here we are with the Monday morning motion filed by the defense team to recuse Judge Kathleen McCarthy Neyman. We have been over many recusal motions in our short time here on the Tubes of You. And as I tell you all the time, I tell you, judges are supposed to avoid even the appearance of impropriety. Even the appearance of impropriety. It is not enough to just be like, trust me, bro, I don't know them. And so just trust me. I don't care how it looks. I mean, they're supposed to avoid even the appearance of impropriety. We went over the motion for Judge Cannoni to recuse herself in the Karen Reed case before Karen Reed's first trial. And she heard that motion herself and she declined to recuse herself despite potential evidence that she may have known or have rented her beach house to some of the witnesses in the case. And they even had a big board that they held up with a Venmo transaction between Ryan Nagel and Julie Nagel for Frank and Beverly. And it's wild. We could see it a mile away that this judge had some kind of chip on her shoulder, that there was something going on here that was a little bit deeper than this whole thing, right? Did she have ties to Justin? What was it? We couldn't understand why she was being this way. people are like, oh, she must hate Bradl because he represents Turtleboy. I'm like, yeah, no, I don't think that's it. Let's read the motion to recuse, find out what Bradl and his team uncovered, and then I'll tell you what happened after that. This is defendant's motion to recuse Judge Kathleen McCarthy Neyman and request for evidentiary hearing. Let me get my highlighter out. Oh, please. I'm parched. Okay. Introduction. Now comes the defendant, Kelsey Fitzsimmons, by and through counsel, and hereby files the incident motion to recuse Judge Kathleen McCarthy Neyman. As grounds, it is apparent that a reasonable, disinterested observer, being apprised of the facts of the judge's involvement in the case, would conclude that there is a lack of impartiality, or at a bare minimum, an appearance that the judge's impartiality might reasonably be questioned. The instant motion is made pursuant to the Due Process Clause of the 14th Amendment of the U.S. Constitution, Article 29 of the Massachusetts Constitution, Declaration of Rights, the provisions of the Supreme Judicial Court's Code of Judicial Conduct, and any applicable case law, all of which mandate disqualification when a judge cannot be fair or impartial, or where her impartiality might be reasonably questioned by a disinterested third party. Here, the record demonstrates multiple grounds, each independently sufficient and collectively dispositive, requiring recusal. Request for evidentiary hearing. As the body of evidence required to be amassed in support of the motion likely includes, but is not limited to, probation officials, probation officials, municipal third-party records, social media information and the like, an evidentiary hearing and its attendant subpoena power is necessary to introduce the evidence and make sure the record is clear. Applicable standard. A judge must disqualify himself in any proceeding in which a reasonable person, knowing all the circumstances, would question the judge's impartiality. We did a poll one day. We did a poll because I was like, I wanted to take your pulse on whether you guys thought that there was the appearance of impartiality. And it was overwhelmingly yes, she was not being impartial. The inquiry does not turn on the judge's subjective belief in his own neutrality, nor does it require a showing of actual bias. This principle of impartial justice is enshrined in Article 29 of the Massachusetts Constitution, Declaration of Rights. It is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. Those are strong words. And this is the case from 1930. A rigid adherence to that principle is essential to the maintenance of free institutions. It may never be relaxed. In fact, litigants and visitors to the Supreme Judicial Court at the John Adams Courthouse in Boston are greeted with one legal principle to the exclusion of all others in the vestibule, the words of Article 29. The protection of an accused's rights to an impartial adjudicator is prominent in both the United States and Massachusetts constitutions. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. Actual impartiality alone is not enough. Our decisions and those of the Supreme Judicial Court have commented often and in a variety of contexts on the importance of maintaining not only fairness, but also the appearance of fairness in every judicial proceeding. In other words, an accused's constitutional right to due process demands that justice satisfy the appearance of justice. In ruling on a motion seeking recusal for an actual, apparent, or potential transgression of Article 29 and the Code of Judicial Conduct, a judge must consult first his own emotions and conscience. If he passes the internal test of freedom from disabling prejudice, he must next attempt an objective appraisal of whether this is a proceeding in which his impartiality might reasonably be questioned. If the answer is positive, the judge must grant the recusal motion regardless of such consequences as trial delay, which are immaterial. See the Code of Judicial Conduct. SJC Rule 3:09, Canon 3E1, which in pertinent part provides a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned. Note the language is shall. It is not optional, my friends. It's not optional. A judge is disqualified from any matter. What's going on here? From any matter if the judge cannot satisfy both the subjective and the objective standard. The subjective standard requires disqualification if the judge concludes that he or she cannot be impartial. The objective standard requires disqualification whenever the judge's impartiality might reasonably be questioned by a fully informed, disinterested observer, regardless of whether any of the specific provisions of paragraph A1 through 5 of section 2.11 apply. Karen D. Pasquale is like, can someone please send this to Lisa Lott? There was a recusal motion made before trial by Ahmad Cruz. It was denied. The standard focuses on public confidence in the integrity of the judicial process before the court. The standard focuses on public confidence in the integrity of the judicial process before the court. How many of you, if you've been watching the Faust trial, have grave concerns about the integrity of the judicial process before the court? Anyone? I mean, it is out there for the world to see. The difference between the way that judge has been treating Mr. Ahmad Cruz and the way she treats the prosecution. Recusal is required where a judge has a personal or economic interest that could be substantially affected by the outcome, has engaged in ex parte communications concerning a pending matter, has become personally embroiled with parties, counsel, or witnesses, or has taken actions that, viewed cumulatively, undermine the appearance of impartial adjudication. And that is in the Code of Judicial Conduct in Massachusetts. All of these recusal categories are present in this case. Let's see. Procedural background relative to recusal. Ms. Fitzsimmons is before the Essex Superior Court, sitting at Salem in a one-count prosecution charging back to one. Ms. Fitzsimmons is before the Essex Superior Court, sitting at Salem in a one-count prosecution charging assault by means of a dangerous weapon. Judge McCarthy Neyman presided on the case on August 14th, 2025, for a bail petition in Essex Superior Court. On August 28th, 2025, for arraignment, September 9th for a bail hearing, and September 11th for an emergency motion for immediate relief from Scram. That's the hearing that we listened to together after I was able to pay for and buy the recording because there was no Zoom. They don't do Zoom in Essex County. They do like something like a party line. We have to call on a phone number. On both August 14th, 2025 and August 28th, 2025, Judge McCarthy Neyman was assigned to Salem Civil A, Courtroom H, handling civil business in the Salem Superior Court. And they've attached the judicial assignment sheet proving it. There's the receipt. We like receipts. Nonetheless, she appeared and handled both the bail petition and the arraignment in the criminal session without any verbal or written explanation in court or on the docket. She just parachuted herself into the court proceeding of Kelsey Fitzsimmons. Why? Why? She was supposed to be handling civil cases. Nonetheless, the assignment sheet, sometimes I highlight just to find my place. The assignment sheet for September 2025 attached as Exhibit 2 also reflects her assignment to the same civil session. Nonetheless, she continued to leave the civil session and handle criminal business in Ms. Fitzsimmons' case, still without explanation. Without notice to the parties or the public, it appears she has specially assigned herself to this case. A one-count, simple 2 or 3 day trial where a conviction warrants only a sentencing guideline sentence of straight probation. The assignment seems inexplicable on the merits of the case and raises questions about the motive of the court so as to undermine the public's confidence in the ongoing adjudication. We like to say it strains credulity. We've got the merch. We've been saying it strains credulity since the Maya Kowalski trial. Next section is called Grounds for Recusal. Grounds for recusal. Prejudgment reflected in a dangerousness finding and other pretrial matters. Zoe, is it your birthday too? Let's not spoil it for the people who don't know the ending. Let's not spoil it for people who don't know the ending, okay? Okay? If you know the ending, just, try and keep it to yourself. I know it's hard. But try. Please. In upholding prior dangerousness findings and herself finding Ms. Fitzsimmons dangerous under Section 58A, the judge has been privy to and has adopted as fact evidence that would not come into a trial of the underlying charge. The court has made a subjective personal finding that Ms. Fitzsimmons is a dangerous person. She has repeatedly referenced her belief, necessarily by clear and convincing evidence, that Ms. Fitzsimmons is an ongoing and present danger to her assailant, Officer Noonan, who needs the protection of a dangerousness finding from her. Noonan. The court has also gone so far as to explicitly prevent any potentially favorable family court custody or visitation orders by prohibiting Ms. Fitzsimmons from seeing her infant child, regardless of any custody determination in that court. This is a highly unusual finding, unprecedented in undersigned counsel's experience, that a superior court judge would impair the family court in performing its own core function in determining custody and visitation in the first instance. This court has gone far out of its lane in an effort to keep Ms. Fitzsimmons from her infant. The court's findings in these areas amount to an expression of her opinion on the character and guilt of the defendant. There are several relevant legal guideposts for the proposition that a judge who makes adverse pretrial findings on a case should avoid sitting as the trial judge. In a case that they cited earlier from 1992, the trial court's findings that the defendant was untruthful in the past and its failure to recuse at the jury trial was found to be an abuse of discretion by the appeals court. The appeals court found his actions constituted error because if, after applying the 2-part test of SJC, one of the canons of ethics for judges, a judge finds that he should disqualify himself under either part, he must allow the motion. Possible consequences of his recusal on the commencement of the trial are immaterial. Further, a judge cannot partially recuse himself. Once a judge concludes that there are grounds for recusal, he must completely disassociate himself from participating in the case. Ordering a jury trial, as the judge did here, does not substitute for allowance of a recusal motion. And this is not referring to this case. This is talking about quoting directly from this case called Parento. Let me just move on to some of the facts of this case. I will scroll through in case you want to read the whole entire thing yourself. In Parento, the court's pretrial findings regarding untruthfulness of a party were dispositive for recusal from the trial, and selection of a jury was not a remedy. The foregoing findings against Ms. Fitzsimmons are equally dispositive for recusal and are further supported by the present court's comments against counsel. Here, in its order dated September 16th, 2025, document number 19, this court has alleged that defense counsel did not transparently provide information resulting in a, quote, manipulation of the court relative to defendant's physical condition. Footnote 1. Which reads, the defense believes the court possesses extrajudicial ex parte information that is speculative, misleading, or incomplete that drives this assertion. Ex parte is when the judge talks to the other side without the other side, and that's completely improper for a judge to do. In any event, no such extrajudicial information has been disclosed by the court, nor has there been an opportunity for the defense to respond, which is required by the Code of Judicial Conduct. See Section 2.9a, relative to disclosure of ex parte communications. See also infra, section addressing ex parte communications with probation concerning a pending matter. Well, we're going to get into that a little bit. The defense denies the claim and has not had any opportunity to address it. In any event, the court's personal conclusion in this regard gives the appearance, as well as the actuality, of partiality on the part of the court, requiring a recusal, as was the case in Parento. Any other result would be an abuse of discretion. Ex parte leading to ipsy dixit. Ipsy dixit, because I said so. Thanks, Sam. Comment 3 to Rule 2.6 of the Code of Judicial Conduct also addresses similar circumstances where a judge is exposed to settlement or plea discussions and states judges must be mindful of the effect settlement or plea discussions can have not only on their objectivity and impartiality, but also on the appearance of their objectivity and impartiality. Despite a judge's best efforts, there may be instances where when information obtained during such discussions could influence a judge's decision-making during trial. And in such instances, the judge should consider whether disqualification may be appropriate. Happy birthday, Vanessa. Adverse findings in the 58A context involve the same negative connotations as partiality against defense counsel, plea, or settlement discussions, and should be included in the same calculus for a sitting judge on both the subjective and objective prongs as to whether an appearance of bias exists. Then they go on to talk about some more law and some more reasons why they believe that this judge has shown bias. And this particular notes to Massachusetts Rule of Criminal Procedure 30 says, the rule recognizes that prior findings and proceedings can taint objectivity and that recusal should be liberally exercised, especially where the moving party requests it. The court's prior findings relative to the character and fitness of the defendant as a mother, as well as the court's criticism of defense counsel, conclusively demonstrate that the court's objectivity is tainted, warranting recusal. Here's my favorite, well, one of my favorite parts. Finally, the court's demeanor and actions at the September 11th, 2025 pretrial hearing also provide ample grounds for recusal. Rule 2.3 provides a judge who manifests bias or prejudice or engages in harassment in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. disrepute. A judge must avoid words or conduct that may reasonably be perceived as manifesting bias or prejudice as engaging in harassment. The recording of the hearing accurately preserves and demonstrates the court's prejudicial demeanor and actions and should be grounds enough for the court to step in. For the court to step off the case on appearance grounds. The defense would admit a copy of the recording at the recusal hearing. That recording was horrific. The Massachusetts legislature also has recognized through the passage of a general law 218-26A that a judge who considers prior adverse findings against a defendant through plea negotiations should not sit on a trial for the same litigant. And then they go on to say, the legislature has provided a blanket veto to the defense where such information has been tendered pre-trial. In the circumstances that bar, meaning this case, a judge who has rejected the defense request for release and found her dangerous and unfit should not, sitting in pretrial judgment of a defendant should not handle the trial of this matter. Judge McCarthy Neyman should recuse herself from the trial and any further substantive pretrial proceedings. Findings of dangerousness and parental unfitness when viewed in conjunction with ex parte communications. Oh, the Bakers are here. Hi, Bakers. Didn't pop up on my thing. Personal accusations against counsel and the judge's own extrajudicial interests all combine to demonstrate that this court has prejudged critical issues central to the case. Continued participation might, in quotes, might, because that's a standard, might cause a reasonable observer to doubt the judge's inability to approach subsequent proceedings impartially. Roman 2. Personal and economic interest creating an appearance of bias. Buckle up. Basic internet research shows that Judge McCarthy has resided in the town of North Andover for approximately 25 years. Public real estate records indicate she's a listed homeowner in the town. She was the founder and principal of the law office of Kathleen McCarthy, a criminal defense firm in North Andover, Mass., and is listed in Massachusetts Lawyers Weekly, April 29th, 2020, as a former sole practitioner in North Andover from 97 to 2018. In adjudicating the alleged dangerousness of Ms. Fitzsimmons, a fellow North Andover resident, in a North Andover incident, the court inevitably had to consider the safety of herself, her own family, and former colleagues that work or live in the town. As a tax-paying resident, the judge has a vested interest in the financial security of the town and its reputation in the Commonwealth. Well, there's one. There's one reason she lives in North Andover. On the unique facts of this case, one North Andover police officer, Patrick McCarthy Noonan. Did you hear that? Patrick McCarthy Noonan. Footnote 3, discovery documents provided by the Commonwealth relative to Noonan's training lists his full name as Patrick McCarthy Noonan. It is unknown and undisclosed by the court whether there's a family relationship. Well, McCarthy's a very popular name. It would be wild if they were related. That would be absolutely insane. And I would hope to, tiny Jesus here, that if she was related to Noonan, she would have stepped away. I would hope that. On the unique facts of this case, one North Andover police officer, Patrick McCarthy Noonan, shot and almost killed another North Andover police officer defending Kelsey Fitzsimmons. The police immediately adopted and believed the story of the shooter, officer, and never sought to interview Ms. Fitzsimmons, who fought for her life for 53 days in Massachusetts General Hospital. The case involves only these two officers as percipient witnesses with no body camera video. The defendant has potential for civil claims arising from the conduct of governmental actors in this case, claims that could foreseeably expose North Andover to substantial financial liability. Municipal tort liability directly implicates municipal finances and taxation, and as a resident property owner, the judge has an economic interest that could be affected by the outcome of this criminal trial. Such an interest is disqualifying where it might cause a reasonable observer to question impartiality. Another Essex Superior Court judge, Kristen Buxton, recused herself in similar circumstances as a taxpayer in the town of Ipswich in the matter of Copethorne et al. Versus town manager of Ipswich. Copethorne was a taxpayer suit under General Law Section 40, and Judge Buxton, an Ipswich taxpayer, recused herself, noting an appearance of impropriety. Seeking to ensure the greatest possible public confidence in the court's independence and impartiality, she recused herself due to her ties with the town. She stated, "The Code of Judicial Conduct, SJC Rule 3.09b, sets forth that judges should avoid both impropriety and the appearance of impropriety." She got it. "This is to ensure the greatest possible public confidence in their independence and impartiality. As I am a property owner in the town, and despite no actual conflict, there may be an appearance of conflict." And then they attached that order as Exhibit 3. The appearance of impartiality is compromised when a judge sits in judgment over a case where the outcome may affect her own municipality's financial exposure. Judge McCarthy Neyman should mirror Judge Buxton's decision in Copethorne and withdraw to avoid the appearance of lack of impartiality. And then we get to Section Roman 3, which is ex parte communications with probation concerning a pending matter. And so, while the first 2 points may not be the strongest, the third might take it over the top, and it's the totality of the circumstances here. Oh, please. Undersigned counsel has recently been informed that Judge McCarthy Neyman had an ex parte and undisclosed conversation with Assistant Chief Probation Officer Jeff January on September 10th, 2025. This conversation occurred the day before the court sua sponte revoked Ms. Fitzsimmons' bail and returned her to custody, cut off defense counsel, invited objections from the Commonwealth, walked off the bench when counsel was addressing the court, vilified ACPO January in open court, and was visibly shaking and angry. Counsel was informed by ACPO January and his attorney that Judge McCarthy Neyman came to his office unannounced the day prior to his hearing. She sought to investigate the status of Ms. Fitzsimmons' compliance with probation terms and was informed by ACPO January that there was no violation. He also said that when he was on the stand during the hearing, because he did take the stand. Hold please. ACPO January recalls that he discussed the fact that he had email communications with undersigned counsel, which appeared to upset Judge McCarthy Neyman. When ACPO January mentioned that his emails favorable to the defense, which were likely attached to the motion filed for relief, Judge McCarthy Neyman abruptly left ACPO January's office. There was no legal justification for the court visiting his office and conducting its own investigation outside the presence of defense counsel, off the record and without subsequent disclosure to the defense. Masked out, if you could not spoil it for the people who don't know the ending, I would really appreciate it. Love you so much. Thank you. Some people don't know the ending. There's always a, but wait, there's more. These ex parte communications concerned matters bearing directly on the defendant's liberty, which was at stake, unbeknownst to the defendant the very next day. Such conduct directly violates Rule 2.9, prohibiting ex parte communications. Where a judge receives information outside the adversarial process and then presides over related proceedings, the appearance of impartial adjudication is irretrievably lost. Roman 4, personal embroilment with probation and defense counsel. Undersigned counsel was recently informed that following the September 11th hearing on the emergency motion for relief, Judge McCarthy Neyman filed a complaint against ACPO January arising from this case. This is despite her unclean hands engaging in ex parte conversations in the probation office. Upon information from ACPO January's attorney, the complaint filed by McCarthy Neyman included accusations of defense counsel colluding with probation. Yep, things that make you go, Things that they don't want you to know about. Mercury says, is that why she said to him in court, there's no question pending? Finally, she filed a complaint after the hearing against the assistant chief of probation. Mastad, I don't know. I don't have all of the exhibits. I don't know. I can't answer your question. I'm not calling Tim Bradl a liar, so if that's what you're doing. I do not think that an officer of the court, I do not think that Tim Bradl would put this into a public court filing if it wasn't true. He spoke to Jeff January's lawyer. Do you think Jeff January's lawyer is lying to him? There are exhibits. Maybe you don't have them. There's an entire packet of exhibits. Upon information from ACPO's, right. Accusations of defense counsel colluding with probation. As a result, defense team members are now supporting witnesses for ACPO January against the judge in this complaint that directly stems from this very case. As a result, the complaint itself is strong evidence of the court's actual bias against undersigned counsel and/or Ms. Fitzsimmons. At a hearing on the ACPO January probation matter, undersigned counsel would attack this court's position and credibility and assert that the court's complaint is false, baseless, and merely dissatisfaction with an undesired viewpoint from probation. In fact, counsel would also assert that ACPO January at all times acted fairly, truthfully, and professionally. Mr. January did everything that he could to accommodate Ms. Fitzsimmons' disability, unlike the court itself, and deserves praise and the full support of the probation department rather than an assault on his reputation. Further, the court's complaint is proof that the court's foray into ex parte investigation before the hearing simply didn't produce the desired information and resulted in the court vilifying ACPO January the next day at the September 11th hearing. Yep. Remember how mean she was to him? Without any cause whatsoever. In fact, I think she was kind of like surprised that he was even in the courtroom, remember? In addition, and like she was like, how dare you show up to court after my ex parte conversation with you yesterday? Didn't I scare you away? Didn't I scare you away? In addition, and perhaps most compelling for recusal, the fact that the court did not disclose this complaint to counsel for Ms. Fitzsimmons is strong evidence of the judge's bias and lack of impartiality. A judge who has entered the fray, particularly by leveling accusations against counsel of record and court employees who provide good faith assistance to defense counsel, cannot thereafter preside without creating an appearance of partiality. The court must recuse. Well, she certainly has entered the fray. Roman 5, outstanding questions created by the court's conduct. Based on all the foregoing, many questions have been raised that create a scenario where the judge's impartiality might reasonably be questioned. Answers require an evidentiary hearing to obtain facts that would likely show that her impartiality is compromised. The questions are including, but not limited to, the following. Is the judge related to Patrick McCarthy Noonan? Two, why is the judge covering every hearing on this case through the trial? Is there a written order to that effect? Three, why did she repeatedly leave a civil session to cover this matter? Four, what specifically is in her complaint to the probation department concerning ACPO January's actions? Five, why didn't the judge disclose the existence of a probation complaint involving the defense on Ms. Fitzsimmons' own criminal matter? Six, why did the court have an ex parte meeting with ACPO January in his office? Seven, why didn't the judge disclose the meeting and comply with the Code of Judicial Conduct? Did the judge use any inside information obtained against Ms. Fitzsimmons? Eight, why is defense counsel's advocacy perceived by the court as manipulation or collusion? Why is the court using such descriptives which are indicative of bias? Cumulative effect. The SJC has repeatedly emphasized that recusal analysis must consider the totality of the circumstances. Even where individual factors might not compel disqualification in isolation, their cumulative effect may do so. Here, the combination of negative pretrial findings of personal economic interest, ex parte communications against defendant and counsel, prejudicial findings, and personal entanglements with probation and counsel would lead any reasonable member of the public to question the judge's impartiality. Public confidence in the judiciary requires recusal. Relief requested. Wherefore, the defendant respectfully requests that the court grants an evidentiary hearing, order the recusal of Judge McCarthy Neyman, reassign this matter to a different judge by means of reassignment, not involving Judge McCarthy Neyman, and grant such other relief as justice requires. Dated February 8th, 2026. XOXO. Timothy Bradl and Martha Coakley. And then, but wait, that's not all. Because there was a hearing on Monday, the 9th. And Martha Coakley and Tim Bradl spoke to reporters after court. Let's pull up that video. Wild. Just when you think it can't get any crazier over there in Massachusetts, it absolutely 100% does. Okay. Martha Coakley, first woman AG of Massachusetts. Thank you, Mitchell. All right, let's take a look at what happened after court on Monday. I don't even know if, yeah, we were, that was the day we began the Edrick Faust trial. I think, or were we already a weekend? I'm confused about where we even are at this point. We're on day 8. 1, 2, 3, 4. No, we started the Faust trial a week before, but we were, it was a full day of trial that day. And so I was not able to cover that hearing live as I ordinarily would do. So this is Monday after court. Kelsey looking gorge. This is Martha Coakley on the left of your screen. Here's Tim Bradl, the silver fox. All right. The 9th was the hearing, right? That was Monday. Yeah. And the trial started on the 2nd. Okay. Here we go.
We're gonna go quick because it's so cold.
Gotta keep her warm. So you filed a motion to recuse the judge this morning. Can you speak a little bit to why you decided that was a step you wanted to take?
Sure. Martha, why
Yeah.
don't you
Look, this issue of fairness, not having a conflict, and in fact, not even appearing to have a conflict, it's just bedrock in our society. It happens all the time, by the way. State court, federal court, judges, lawyers know each other, family members, financial interests. There's a million reasons why some judge might decide he or she shouldn't sit on a case because they have an actual conflict or because it appears that way to the public. And we felt that in this case, there were lots of reasons why, and we've raised this before, and even the SJC in their last decision said it is up to the judge, him or herself, to decide whether or not there's an appearance of conflict or there's an actual conflict. And so no one should be surprised by this motion, given this case. It's a complicated case. It's had lots of twists and turns. It is unusual, but that also raises some unusual conflicts and appearances in this case. And so we're hopeful that the judge will look at this motion and realize that. It's obviously her call to make that decision. She was not here today, but she'll see the motion and she'll make a decision based on what we filed today. This is for fairness, by the way, in every case, but in this case, this is fairness for Kelsey.
And so there's a hearing set for March 9th. Trial is March 23rd. How likely do you think it is that this case actually goes to trial on that date, given the hearing and then the judge deciding the motion, and then maybe you get an evidentiary hearing?
We're not moving this thing. We want this addressed. We want a jury to hear this case. Kelsey has a lot of work to do in terms of getting her baby back, and that's number one. That's the number one priority here. And we don't want this to interfere any more than it already has. It's been horrible for her, and we need a judge that doesn't have appearances of a lack of impartiality on this case. We want to have that done immediately, as soon as we can. We moved up the date a little bit as best as schedules would allow. So we're eager to get that handled. We're working behind the scenes without court involvement right now anyway on the discovery. We're trying to get the last few bits of discovery, and we're not obligated to provide any discovery to the Commonwealth until they've certified and it's actually true that they've given us all the discovery. So that's the way the system works. We're very confident in this motion that, there's no way that this judge could sit on the case in terms of without demonstrating an appearance of a lack of impartiality. So we want to just get a different judge on the case and move forward as soon as we can.
So the Commonwealth said they were going to file a certificate of compliance either today or this week. You sounded maybe a little less certain that they had actually met their.
Yes, as I said, I was trying to be nice, a little too optimistic, I think, today. But we're working together. We'll try to get it done. And technically, they're not fully in compliance yet. But we're working on it, and I know these things take a little bit of time, but it's time to get it together, get it done.
And last time we were here, you talked about filing some Rule 17 motions. Is that still the plan?
So we're looking at that. We think some of that was covered by the discovery that's already been given, so we might reassess that. We might also just send some trial subpoenas for items as well. I know the Commonwealth is probably going to do that as well for some things too. So there's different ways we can address it. Anyone else?
Yeah. What do you think the likelihood of Judge McCarthy Neyman being recused is?
Well, the motion's very comprehensive, Josie. We think that, you know, it's a very strong motion, and, you know, it's gonna be handled by her on its merits, and we're very confident in it. You know, I don't want to really speculate on, you know, the odds of it, but it looks good, and we're very confident with it. We put a lot of time into it, and there's a lot of issues in there that need to be addressed.
All right, just one more because I know it's cold and I want Kelsey to get warm. Is there any chance that there's going to be a ruling before the trial, or do you think they're going to like drag it out?
Yeah, no, I think that the 9th is a realistic date, and we're going to do everything we can behind the scenes to make sure that date is set up for a hearing. If they in fact want an evidentiary hearing, that as opposed to just recusing, if the judge wants to just have a hearing, that we're going to work hard to make sure it's on the 9th.
And that motion would have to be decided before trial, one way or the other.
Delay is not a factor in whether a judge should recuse themselves. It takes priority, and it's a constitutional right to have an impartial judge. And
There is a squeaking sound that sounds like somebody is on a swing. That's not you, it's them. It's the recording.
it's nothing that's going to be moving for any sort of scheduling or logistical concerns.
And in watching you argue, it's not something that you always file in every case, you know, it's a
Right,
special
it's rare.
circumstance.
It's usually, Martha and I were just discussing this a little while ago. Usually a judge just will see things in the record that would cause someone to question their impartiality and just step off the case on their own. For whatever reason, that didn't happen here. And, you know, sometimes lawyers have to file motions pointing things out to the court, and that's fine. And we've done so, but we fully expect that that this will be taken care of, and that we'll have a fair, impartial judge on the case.
Thank you, everybody.
Thank you.
Thanks, guys.
All right, so that's that.
A brand new motion.
Hello, brother counsel. I guess he's already done this because it went right into that. Okay, so what had happened was the very next day, on the 10th, Tim Bradl put out press release, and here it is. The defense team for Kelsey Fitzsimmons is pleased to release today's decision from the Chief Justice of the Superior Court, issued just one day after the filing of our comprehensive motion seeking the recusal of Judge Kathleen McCarthy Neyman. In the court's order, the Chief Justice determined that the recusal motion was moot in light of some unspecified intervening administrative action, noting that, quote, the judge is scheduled to sit in another session during the period of the remaining pretrial and trial of this case. As a result, Judge McCarthy Neyman will no longer preside over the pretrial proceedings or the trial of this matter. Wow. Interesting timing, too. I mean, I think that is like the fastest that any motion has ever been decided. It was lightning quick. And so whatever happened must have been, in my opinion, sufficiently egregious enough for the Chief Justice to step in and say, yeah, not on my watch. We already got enough problems with our judiciary in Massachusetts. Not on my watch. And yet just couched it as a transfer. Or just saying that, oh, the judge was already scheduled to be somewhere else, so don't worry, she's not going to be on your trial. While the order does not specify the timing or source of the administrative assignment, the practical effect is clear. Judge McCarthy Neyman will not continue to sit on this case moving forward. This outcome directly addresses the core concern raised in the defense's motion, namely the necessity of preserving the fairness, impartiality, and appearance of justice throughout the remainder of the proceedings. Yay for Kelsey. The defense team appreciates the court's prompt attention to these issues and remains committed to vigorously defending Ms. Fitzsimmons' constitutional rights as this case proceeds. We will continue to advocate for a fair adjudication grounded in due process, transparency, and the rule of law. Further updates will be provided as appropriate. So there it is. They didn't even have to wait for a decision on the motion. Chief Justice said, oh, don't worry about it. No big whoop. She's supposed to be somewhere else. She's not going to preside over your trial, which is scheduled for March 23rd with a conference on March 9th. Funny the way it is, if you think about it. Hi, not fade away, Kai. Happy birthday. She says, also, I got to play with the women's ice hockey team in high school prior to a game here in the States. It was awesome. That's amazing. You're a ice hockey player too? Ice hockey player, I mean. Thanks for your 10. I appreciate you so much. Norman, thank you for your 20 and for the wishes. I appreciate you. Megan says, one day apart. I love that for us. Happy birthday, Queen. I love you with all of my heart. Happy birthday, Megan. I hope your day was amazing yesterday. I think Jennifer Aniston's birthday is yesterday too. So you and Jennifer Aniston are birthday twins. Music to my soul. Have a cupcake. Happy birthday. Love you. Thank you for your super chat. Adventurous Spirit says, happy birthday. The best lawyer on YouTube. Happy birthday also to the cupcakes who share this special day. There's a lot of them in the chat, right? Nope. They didn't answer any of those assertions. And so the judge does not have to explain herself, right? Thanks to Shy. She says, red is my color. Happy birthday. Thank you to Shy for your super chat. Charlie says, I'm late, but Judge Lott is a biased control freak. Oh, thank you, Charlie. Charlie, it's a good thing you live in Australia. Otherwise, she might come for you. Thanks, Charlie. Bima says, I have waited to hear this Kelsey Fitzsimmons motion because I only allow Melanie to read me the papers. Oh, thanks. Thank you so much for your 10. I appreciate you so much. Kelly said, happy birthday. I remember as it's my birthday today as well. Another birthday. Thanks, Kelly. Happy birthday to you across the pond. And you're 50 today. Happy birthday. 50 is the age where you suddenly realize you have no more F's to give. It is a beautiful, freeing age. So happy birthday to you. Let me know how long it takes. And happy birthday to other cupcakes who share this birthday as well. And it is also Vanessa's birthday today. Happy birthday, Vanessa. Ellen says, everyone remember that some girl from high school feels like Kelsey didn't like her, and that ended up in a court document. Thank you very much. Max, thanks for your 5, says, happy birthday. It's not the years of your life. It's the life in your years that matter. XO. Thanks, Max. Strange Credulity gifted a membership because she's amazing. Thank you. And Kelly said, just been reading on proving judge bias in Georgia. Apparently adverse rulings and opinions made on the evidence aren't usually grounds for bias and recusal. Yeah, you can look up the recusal motion that has already been filed, and you can find that in the court docket. I tried to get into mass courts this morning, and mass courts was down, so I don't know what the hell's been going on. Not a House defendant said that there was a directed verdict granted in Arizona versus Michael Turney. I did not follow that case, but that is good to know. Thank you. It's very rare. Brenda says, Jeff January is a hero. He knew she was crooked, and he told. Thank you very much for your super chat. Look at Charissa gifting 5 memberships. Thank you. Thanks, Charissa. And Dr. Jen Toxic says, happy birthday. Thanks for all you do. Thank you for your 20. I appreciate you so much. And Yacht Club merch, I didn't get to it yet. Because there's a couple of tweaks that I want to make to it. And so we don't have it just yet. But yacht today, Satan. Yacht today, Satan. Thank you very much, Bima, for reminding me of all of the things I need to do after I get off the air for 8 hours. It's been like this Faust trial has been like physically draining. It is physically and emotionally draining. And look at Susan gifting 5 memberships. Thank you, Susan. And welcome to all the 5 new members. It has been so physically draining and emotionally draining that it's just impossible for me to get off the air after 8 hours and then try and pivot and read all of these documents. And, it might not look like it, but there's a lot of preparation that goes into these shows, a lot of preparation. Thank you. All right. Let us take, we're going to pivot now. A moment. Just give me one moment. Mama Shea, thank you for your $75 birthday cash app. I love you so much. You're my queen. She says I'm her queen, and I say you're my queen. Donna, thanks for buying a matcha latte. I appreciate you so much. Jackie 1111, thanks for buying me 3 matcha lattes. I need all the matcha latte I can get. Thank you so much for the birthday wishes. I appreciate you so. All right. Moving on to the next order of business, which is 4 arrests have been made in the death of Enrique Delgado Garcia. And we have been waiting for this for a very, very long time. Just get in here for a second and close some of these windows because it's getting on my computer. It's getting real drafty in here. Let us first take a moment. Praise be. We have been waiting so long for some information on the investigation into the death of MSP trooper trainee Enrique Delgado Garcia, which happened approximately 16 months ago, where he was killed during a boxing training exercise at the police academy in, where was it? Somewhere Braintree, Massachusetts. I want to first watch the press conference with you. This press conference was on the 9th. So this was also on Monday. All of these things happened on Monday. And pivoting was really impossible for me. I was too exhausted. Okay, so, but now we have a chance to go over it all together. First, let us watch the press conference from February 9th by Attorney General, Massachusetts Attorney General, Andrea Campbell, and David Meyer, who was the special, I think he was the special counsel hired to investigate the death of Enrique Delgado Garcia. I have a whole playlist on Enrique. If you are not familiar with the case, I will link it in the show notes below when I get a chance after we are done here today. Here is the presser. This is about 16 minutes long. Finally, New Braintree, which is not near Braintree. Thank you. It was like a Braintree. It was one of the Braintrees, right? Thank you, Libby. Here we go.
I know. Good morning. Okay. Good.
Do you see her? What she turns? She turns to David Meyer and she says, "How are you doing? Are you doing okay?" I think that's David Meyer that she's talking to, but we will see. Mastad pointing out that he's a former ADA in homicide and current defense attorney, top-notch guy. I'm trying to remember what he was involved in. And his name is familiar. Maybe it's from this case. Maybe it's from something else. Okay, here we go.
Good afternoon, everyone. Thank you for being here. On September 13th, 2024, Massachusetts State Trooper Enrique Delgado Garcia died while training to become a Massachusetts State Trooper. He sought to become a state trooper to fulfill his dream of serving and protecting the people of the Commonwealth of Massachusetts. Shortly after Enrique's death and after consultation with Worcester District Attorney Joe Early, I appointed an independent investigator, Attorney David Meyer, to review the facts surrounding Enrique's death. I want to thank Enrique's family, his friends, his fellow trainees, and the public for their tremendous patience as this process unfolded. I know that to some, this process has felt long and opaque.
Just want to point out that the district attorney, Joe Early, for Worcester, recused himself from this investigation because, again, you're supposed to avoid the appearance of impropriety. And it is because Enrique Delgado Garcia was a victim witness advocate in the Worcester County DA's office. And so he felt that even though he may not have a conflict, it felt like a conflict. And so that is why they appointed a special, what did she call him? A special investigator? Hold on. Joe Early said, my office should not be investigating this. And that was the right thing to do.
Delgado Garcia. Good afternoon, everyone. Thank you for being here. On September 13th, 2024, Massachusetts State Trooper Enrique Delgado Garcia died while training to become a Massachusetts State Trooper. He sought to become a state trooper to fulfill his dream of serving and protecting the people of the Commonwealth of Massachusetts. Shortly after Enrique's death and after consultation with Worcester District Attorney Joe Early, I appointed an independent investigator, Attorney David Meyer, to review the facts surrounding Enrique's death. I want to thank Enrique's family, his friends, his fellow trainees, and the public for their tremendous patience as this process unfolded. I know that to some, this process has felt long and opaque. Independent investigations are careful and thorough by necessity. In order to maintain the integrity of their process, certain aspects cannot be shared with the public. That confidentiality is by design to ensure fairness for everyone involved. Enrique was a public servant. He began his career in the Worcester District Attorney's Office as a victim witness advocate. His family has spoken openly about his intention of being someone who made a difference in the community and his dreams of becoming a Massachusetts State Trooper. He was a son, a brother, an uncle, and a friend. Enrique should be alive today. Given the extraordinary nature of these events and the complexity of this case, it was necessary to appoint an independent outside investigator. Death investigations are typically handled by the local district attorney. In this case, however, Worcester DA Joe Early appropriately determined that his office had a conflict because Enrique worked in his office as a victim witness advocate. Following conversations with DA Early, we determined that Enrique and his family deserved an investigation that was completely impartial and devoid of any perception or appearance of conflict. That's why I appointed Attorney Meyer. Attorney Meyer has extensive experience both as a prosecutor and a defense attorney, including 12 years in the Suffolk County District Attorney's Office, where he supervised, investigated, and prosecuted death investigations within Suffolk County. He has since served as partner at Todd & Weld. In this case, David investigated the facts of Enrique's death and the circumstances that surrounded it, just as my office or any other district attorney's office and its investigators would have done. My office was briefed about the investigation along the way and provided logistical support. Because of the design of the investigation, Attorney Meyer had his own independent team to conduct the investigation, and he had full autonomy in making investigatory and charging decisions in this case, which he will discuss shortly. I am grateful to Attorney Meyer for his thorough efforts to follow the facts and to seek accountability to those responsible for Enrique's death. In no way is this investigation and the charges it has yielded a condemnation of all law enforcement. The men and women who choose to serve, protect our communities, often in difficult and dangerous circumstances. Our law enforcement members, including those who serve in my very office, are essential to public safety and the rule of law. I know just how much the Commonwealth benefits from the men and women in uniform who serve the public because I see it up close every day. Many officers go beyond their law enforcement jobs, mentoring young people, supporting community programs, actively working in our communities in a very challenging time to build trust. Their service deserves respect and recognition. And just as they protect us, it is our responsibility to ensure that our inspiring officers at the Massachusetts Police Training Academy are protected from preventable harms and to seek accountability when serious incidents occur. There is nothing more serious than the loss of a life. We can both honor the men and women who serve while also still ensuring accountability within a system, especially when someone dies. Lastly, while Attorney Meyer's investigation focused on Enrique's death, there must be serious discussion and action with respect to reforms. I know that the State Police Colonel, Jeffrey Noble, has already undertaken efforts to effectuate change, and I'm grateful to him, and I look forward to supporting him in those endeavors going forward. Because this is an ongoing legal matter, there may be some questions that I cannot answer in order to preserve the integrity of Attorney Meyer's case. We appreciate your continued patience. And at this time, I'd like to turn over the podium to Attorney David Meyer.
I don't know that we've ever watched a press conference together with Andrea Campbell, but I like her demeanor. I like the way she's a very calming presence, and I like her. What's her general reputation in Massachusetts? Let me know.
Thank you, Attorney General Campbell, and good afternoon. On the day that I was appointed as independent counsel, I made a commitment to the family of Enrique Delgado Garcia, to the Massachusetts State Police, to the public, and to the criminal justice system, that I would conduct the investigation professionally, thoroughly, and independently. I pledged to follow the facts and the law, to perform my work conscientiously and responsibly, and to exercise my independent judgment to reach whatever results the facts and the law dictated. I committed not to permit the speed of the investigation, the length of the investigation, or any other outside factors to influence the investigative process. I owed that to the family of Enrique Delgado Garcia, to the Massachusetts State Police, to the public, and to the criminal justice system. When Attorney General Campbell appointed me, I knew nothing about the facts surrounding Enrique Delgado Garcia's death or about the State Police Training Academy. I had no preconceived notion of the potential outcome of the investigation. With the support of an independent investigative team, my assignment was to gather the facts through any and all available investigative means, taking as much time as we needed to do things the right way, and to follow those facts and the applicable law wherever they may lead. I fully recognize that the investigative process has been lengthy and it has been conducted in silence, without public comment, at least on my part. That silence has been purposeful. It is a direct reflection of the nature of the investigation and of my ethical and legal obligations. At the same time, I can assure the public that the investigative process has been searching, it has been exhaustive, and it has been without outside influence. Given some of the challenges posed by the
Suze, they said it was September 13th, 2024. Thought it was September 13th, 2024, not 2023. Was she wrong in her initial notes? Because I took notes.
Investigation, early last year, I sought judicial approval from the Chief Justice of the Superior Court to impanel a special statewide grand jury in order to conduct an independent fact-finding investigation into the circumstances surrounding the death of Enrique Delgado Garcia. The impanelment of a special statewide grand jury enabled us to compel the testimony of witnesses, to memorialize testimony under oath, to subpoena relevant documents and information, and to gather the facts in a formal proceeding before an independent body. At each stage of the process, the investigative team and I met with the family of Enrique Delgado Garcia to update them on the status of the investigation. We met with the family this past weekend, and we spoke to them this morning. Over the course of the past 9 months, the grand jury has heard sworn testimony from over 150 witnesses, the vast majority of whom have been state police officers. And the grand jury has...
That's why it took so long. That's why it took so long. They had to interview all these people. They had 150 witnesses at the grand jury. That's a lot. Right?
reviewed close to 350 physical exhibits, the vast majority of which relate to policies, procedures, activities, and events at the State Police Training Academy. The evidence gathered by the special statewide grand jury has revealed that in the days and weeks prior to September 12, 2024, members of the State Police Training Academy committed a series of wanton and reckless acts in connection with various defensive tactics and physical confrontation training exercises.
Yeah, so here's the thing. So the boxing training exercise, they call it fight night in some places, was September 12th, and Enrique died the next day. And he was posthumously awarded his shield. Very sad. Yeah, we're not doing politics here. We don't do politics here. Thank you. Here we go.
Conducted at the academy. The facts and circumstances underlying the wanton and reckless conduct include both A, affirmative acts by academy staff, and B, the failure of academy staff to take certain actions or omissions that they had a legal duty to perform during their daily interactions with the trainees, who were under their care, guidance, and supervision. The wanton and reckless conduct resulted in Enrique Delgado Garcia suffering concussion-like symptoms as the result of unauthorized, unapproved, and unsupervised boxing-related sparring exercises that occurred during academy training activities on Wednesday, September 11, 2024. The wanton and reckless conduct culminated in Enrique Delgado Garcia suffering multiple blunt force injuries to the head and massive brain bleeding as the result of the failure of academy staff to intervene and bring a stop to a competitive boxing match between Mr. Delgado Garcia and a fellow trainee that occurred during academy training activities the following morning on Thursday, September 12, 2024. Mr. Delgado Garcia died the following day, September 13, 2024, as a result of the head injuries sustained during the recruit-on-recruit boxing match that Thursday morning. Based upon the facts and the law, the evidence gathered by the grand jury compels criminal prosecution of certain members of the Academy's Defensive Tactics Unit, the supervisor of the unit, and 3 full-time instructors. These individuals engaged in ongoing interactions with Enrique Delgado Garcia on September 11, when he suffered concussion-like symptoms, and on September 12, when he was knocked unconscious. These individuals also had direct management and direct control over the physical training exercises themselves. Factually and legally, each of these individuals owed a duty of care to Enrique Delgado Garcia and to his fellow trainees. Each of them interacted with Mr. Delgado Garcia and his fellow trainees on a daily basis. And each of them committed a series of wanton and reckless acts and omissions that resulted in Enrique Delgado Garcia's death. Given their roles and responsibilities on the Defensive Tactics Unit and their control over the training exercises, the wanton and reckless conduct committed by these individuals violated 2 criminal statutes in particular. General Laws, Chapter 265, Section 40, alleging the crime of causing serious bodily injury to a person participating in a training program involving physical exercise, and General Laws, Chapter 265, Section 13, alleging the crime of involuntary manslaughter. In addition, the evidence demonstrated that when the supervisor of the Defensive Tactics Unit was asked specifically under oath before the grand jury when it was that she first learned about Enrique Delgado Garcia's concussion-like symptoms, she repeatedly responded falsely. Given the circumstances of this investigation and the nature of the information at issue, her testimony before the grand jury violated General Laws, Chapter 268, Section 1, alleging the crime of perjury.
They're prosecuting for perjury in Massachusetts. They're prosecuting for perjury, praise be, under her eye. And the officer, the female officer who's being prosecuted for perjury, just happens to have been on Boston's Finest with Brian Albert, you say? What? Yep. Yep.
Now, each of these charges are merely accusations.
There's no
Each of
settlement.
these
Hold on. Let's
individuals
not
is
get confused,
presumed-
Tina. These are not civil charges. These are criminal charges. So there's no settlement going on here. These people could go to jail on manslaughter charges. Okay. Fight Club. It's like Fight Club. Fight night. Here we go.
To be innocent, unless and until proven guilty. Now, each of these charges are merely accusations. Each of these individuals is presumed to be innocent, unless and until proven guilty in a court of law. These individuals have not been and will not be arrested. I have requested that the court issue a summons for their appearance at an arraignment hearing to be scheduled in the near future in coordination with the court and with their individual attorney.
There's not going to be a perp walk. They're not going to bang the door down like they did to Karen Reed, even though they knew that she had an attorney, and they didn't let her self-surrender because they wanted the body cam footage on that and they wanted the perp walk on that. But they're going to let these guys and gals just turn themselves in for arraignment at a date that, as far as I know right now, has not been determined. No perp walk for these guys like they did for Matthew Farwell while the feds did that. That was the feds. These are state charges. But at least it's something.
Attorneys for their appearance at an arraignment hearing to be scheduled in the near future in coordination with the court and with their individual attorneys. With respect to each of these charges and each of these individuals, I have intentionally not referred to any of the specific underlying facts that were gathered and considered by the grand jury. Given my ethical and legal obligations, this is neither the appropriate time nor place to do so. Given the paramilitary structure of the State Police Training Academy, various members of the Academy command staff had the authority and the ability to address many of the circumstances surrounding Enrique Delgado Garcia's death. At the same time, the evidence before the grand jury demonstrated that the nature and extent of their personal knowledge, personal involvement, and personal participation in the specific acts and omissions that resulted in Enrique Delgado Garcia's death were insufficient to support criminal charges. Based upon the evidence, a reasoned and responsible evaluation of the facts and the law does not support criminal prosecution of members of the Academy's command staff, nor does my professional respect for and commitment to the rule of law.
Yeah, they didn't bring the fugitive task force to or whoever to, like they did to Aidan Kearney's kids' bus stop. So they're not being arrested. They're being given a ticket to appear, an appearance ticket to come to court at a date that he's not discussing. And so let's just take that back a moment.
That resulted in Enrique's nature and extent of their personal knowledge, personal involvement, and personal participation in the specific acts and omissions that resulted in Enrique Delgado Garcia's death were insufficient to support criminal charges. Based upon the evidence, a reasoned and responsible evaluation of the facts and the law does not support criminal prosecution of members of the Academy's command staff, nor does my professional respect for and commitment to the rule of law. Insofar as I have shared with you generally that certain wanton and reckless acts and omissions compel the criminal prosecution of certain members of the Academy's Defensive Tactics Unit, I want to ensure that certain additional facts are made abundantly clear. Based upon the testimony and the exhibits before the grand jury, there is no evidence that Enrique Delgado Garcia was targeted in any way. There is no evidence that anyone, Academy staff, fellow trainees, or any others, harbored any personal animosity towards Enrique Delgado Garcia. There is no evidence that anyone acted with deliberation, premeditation, or malice. One final comment. I take no personal satisfaction, none, from where these facts have led. But I am confident that the investigative team and I have carried out our assignment professionally, responsibly, and independently. And I am confident that we have done so the right way and for the right reasons. Thank you.
Well, why didn't
I
they?
also want to talk.
Oops. They didn't announce the people that they arrested. They didn't announce the people that. All right, hang on. I have another news story on that. I thought we could get it all in one. They didn't announce the people that they're charging. Oh, please. A supervisor and 3 instructors are facing criminal charges in Enrique Delgado Garcia's death stemming from a 9/12/24 boxing training exercise. They usually make me suffer through a commercial first, so just hold please while I do that for you, because you guys are worth it. Boop. Hold please. Coming at you. All right, can we go? I gotta rewind a little bit. And then we can look at the indictments together. This is from NBC Boston 10.
More than a year later, charges have been filed against 4 people related to the death of State Trooper Enrique Delgado Garcia. He died participating in a boxing exercise at the police academy in 2024. Today, an independent investigator announced the results of an investigation. Our NBC 10's Oscar Margain is live for us in Worcester. Oscar, you've been trying to track down those troopers who have been charged. I know tonight, did you have any luck with that?
Hey, Colton, well, no, none of them have actually provided us comment yet on these charges, which stem from an independent investigation.
The evidence gathered by the grand jury compels criminal prosecution of certain members of the Academy's Defensive Tactics Unit.
The Massachusetts State Police rocked by Monday's announcement of criminal charges against a State Police Academy supervisor and 3 instructors. It's the result of a 9-month-long independent investigation into the 2024 death of Trooper Enrique Delgado Garcia.
We can both honor the men and women who serve while also still ensuring accountability within a system, especially when someone dies.
The findings reveal Delgado Garcia suffered from concussion-like symptoms as a result of unauthorized, unapproved, and unsupervised boxing fights during academy training. Investigators say a special statewide grand jury heard testimony from over 150 witnesses and 350 pieces of evidence that ultimately led to indictments. Lieutenant Jennifer Penton, Trooper Edwin Rodriguez, Trooper David Montanez, and Trooper Casey Lamonte are facing charges of involuntary manslaughter and causing serious bodily injury, with Lieutenant Penton facing an additional charge of perjury.
Each of them committed a series of wanton and reckless acts and omissions that resulted in Enrique Delgado Garcia's death.
We're just trying to get comment from you as far as, the charges.
We reached out to those troopers. Edwin Rodriguez did not want to comment, while the rest were not reachable Monday night. The Delgado Garcia family attorney glad somebody is being held accountable.
You basically either ignored, overlooked, or just decided you didn't care enough to make sure that that person was protected.
Speaking to us from the Dominican Republic, Delgado Garcia's stepfather tells us the family is pleased with the results of the investigation. But they're feeling many emotions, above all, a sense of justice. He says no one is above the law.
Now, since Trooper Delgado Garcia's death, the state police has made changes to the academy, including a appointment of new leadership, the suspension of the boxing program, and a review of all their training. Now, these troopers that are facing charges in this case, they're not going to be arrested. They're going to be summoned to court at a different date. Reporting live from Newton, Oscar Margain, NBC 10 Boston.
All right, let's take a look at the papers. Please. $265, Section 13. Hold on a second. I just want to look up the law on the manslaughter charge, so we have it here in case we need it. I'm sure we went over it many, many times when we were covering Karen Reed, but the punishment for manslaughter, if you are convicted, is imprisonment of not more than 20 years, up to 20 years. Okay. And here we go. I may just look at one or two because they may be all very similar. This is the indictment for involuntary manslaughter for Trooper Casey Lamonte. All right. How do you pronounce this word? I don't have my video handy with Ben Affleck and Matt Damon. W-O-B-U-R-N. I'm going to say like Woburn. Is it Woburn? Woburn? And only tell me if you know. Only tell me if you know. Woburn. That's what I was going to say. Woburn. Woburn. I was going to say Woburn. That's what I was going to say. Some people are like Woburn. All right. At the Superior Court begun and holden at the city of Woburn or Woburn, within and for the county of Middlesex on the first Monday of February in the year of our Lord, 2026. Woburn. All right, Kristen lives there. She calls it Woburn. I'll allow it. The statewide jurors for the Commonwealth of Massachusetts sitting in Middlesex County on their oath present that Trooper Casey Lamonte on Thursday, September 12th, 2024, during the 90th Recruit Training Troop of the Massachusetts State Police Training Academy at New Braintree in the county of Worcester, did hereby commit involuntary manslaughter, to wit, by affirmative acts as a result of his actions as a member of the Defensive Tactics Unit for the 90th Recruit Training Troop on and or before Thursday, September 12th, 2024, and or by failing to act when he had a duty to act as a result of his omission/failures to act as a member of the Defensive Tactics Unit for the 90th Recruit Training Troop on and or before Thursday, September 12th, 2024 against the peace of said Commonwealth aforesaid and contrary to the form of the statute in such case made and provided. There's your true bill. Signed by the Special Assistant Attorney General, David Meyer, foreperson of the grand jury. And so that is under Section 235, Section 13. And the second indictment for Trooper Casey Lamonte is causing serious bodily injury to a participant in a physical exercise training program. Also, against Trooper Casey Lamonte, on or before Thursday, September 12th, 2024, during the 90th Recruit Training Troop at the Massachusetts State Police Training Academy at New Braintree in the County of Worcester, while having the direct management and/or direct control over the conduct of physical exercise as part of a course of study or training program in any public or private institution, agency, or entity, to wit, as a member of the Defensive Tactics Unit for the 90th Recruit Training Troop at the State Police Training Academy, having direct management and/or direct control over the Defensive Tactics Training Program, did willfully, wantonly, and recklessly cause serious bodily injury to Enrique Delgado Garcia, a trainee participating in the Defensive Tactics Training Program during the 90th Recruit Training Troop. This is a criminal charge that because he failed to intervene. And this is 26540. Woburn, tomato. These criminal charges say that he failed because he had direct management and or control over the conduct of the training, and he failed to intervene. They are not criminally prosecuting the person that he was fighting with. Next up. That's the same one. You have to go goodbye, and then we have to get the next one. Well, let's suffice to say, Trooper Edwin Rodriguez is also charged with it looks like the same charges as Trooper Casey Lamonte. 265, causing serious bodily injury and involuntary manslaughter. Same facts. By failing to act when he had a duty to act. Failing to act when he had a duty to act and affirmative acts. So both of those things. With regard to the manslaughter charge, same one, 265, Section 13. Let's take a look at the only one that I think is different, Sergeant Jennifer Penton. Let's take a look there. Because she's also got the perjury charges. Thank you, Sharif, for sending these to me. They are watermarked. I didn't realize that. But you did send them to me, assuming that I could use them. This is the causing serious bodily injury to a participant in a physical exercise training program, 265, Section 40. The first two troopers that we read about, Casey Lamonte and Edwin Rodriguez, both also charged with the same. This is Sergeant Jennifer Penton. She's the one who was in Boston's Finest with Brian Albert, right? This is the same as the first two that we read. Also charged with perjury. And the allegations for perjury against Sergeant Jennifer Penton are as follows. On June 13th, 2025, at Woburn, in the county of Middlesex, aforesaid did, after being lawfully required to depose the truth before the statewide grand jury sitting in Middlesex County, willfully testify falsely regarding an issue that was a matter material to the issue or point in question, to wit, in substance and effect, while serving as the supervisor of the Defensive Tactics Unit for the 90th Recruit Training Troop at the MSP Training Academy, the timing of when she first learned that Enrique Delgado Garcia, a training at the academy, had complained of concussion-like symptoms after participating in sparring exercises during defensive tactics training on Wednesday, September 11th, 2024, the day before Enrique Delgado Garcia and other trainees participated in boxing matches during defensive tactics training on Thursday, September 12th of 2024. She lied to the grand jury about when she found out that he had a concussion. So here's the order of events. Apparently he had a concussion from the training program on September 11th. September 12th is the fight, and his death was on September 13th. This could have been prevented. This could have been prevented. This is outrageous. And then she has the cojones to go in allegedly and lie to the grand jury about it. She lied. She lied on June 13th of 2025. His death was in September of 2024. (268) sub 1 is the perjury statute. She could have prevented it. Wow. That's even more egregious because we didn't know, as I recall, because it's been a long time since we covered this, because we covered it right when it first happened in September of 2024. We did not know that he had a concussion the day before and that she still let him fight. That's great. Totally preventable. He should be alive right now. Do you think they should go to jail? She's also charged with involuntary manslaughter for failing to act when she had a duty to act as a result of her omissions and failures to act as the supervisor of the Defensive Tactics Unit for the 90th Recruit Training Troop. True bill against her. And you can't make it up. And these are criminal charges, not civil charges. And the fourth person who has not yet been arrested but summoned to appear in court, David Montanez, Trooper David Montanez, charged with causing serious bodily injury to a participant in a physical exercise training program, involuntary manslaughter, and then, but wait, that's not all. Quickly, they were suspended by the Post Commission. Here's the suspension order of Jennifer Penton. Dated February 9th of 2026. And it reads as follows: the Peace Officer Standards and Training Commission hereby suspends the law enforcement certification of the respondent, Jennifer Penton, pursuant to MGL 6E and 555 CMR. The commission has received sufficient evidence that the respondent has been blank, it's all redacted, thus requiring the immediate suspension of the respondent's certification. The respondent's suspension is effective immediately upon receipt of this order by either the respondent or the head of the respondent's law enforcement agency, whichever is earlier. The respondent is hereby directed to surrender, and the respondent's agency is directed to collect without delay any agency-issued credentials and equipment that promote and support the performance of functions associated with service as a law enforcement officer, including but not limited to any uniform, badge, firearm assigned, cruiser, and use of force instruments such as tasers. That was too sweet, huh? Quickly. So let's see. She was suspended. Were they all four suspended? I've got a suspension order on Casey Lamonte, suspension order on David Montanez, and a suspension order on Edwin Rodriguez, all of them. Oh, is that still the, wait, what? No, this is the suspension order. What are you talking about? What you talking about, Willis? We don't know when the arraignments are going to be. So there's that. All four have attorneys. Let's take a look at who their attorneys are. Hold on. Casey Lamonte, represented by Craig McClellan, Esquire. If any of these names ring a bell, let me know. David Montanez, represented by Megan Siddall, Siddall, Esquire. I wonder if these are all union attorneys. Edwin Rodriguez being represented by Joseph Armhine Jr. Jennifer Penton, represented by Vincent Joseph Demore, Demore, D-E-M-O-R-E III. And so I think they're probably represented by union attorneys, but because they've been suspended, I'm not sure. They can appeal their suspensions as far as I know, just like Michael Proctor did. And we will follow that closely as well. A lot of other things to talk about, but we're running out of time here. Did you guys watch the Murdoch appellate arguments? I did. Well, most of them anyway. I didn't watch the whole entire thing, but I do think Alec Murdaugh's going to get a new trial, and I'm here for every minute of it. I think so. All the cases have been impounded. Thanks, Sheree. Do you need some? All right, moving on. Did you guys watch Murdoch? I think he deserves a new trial too. Even if he's 100% guilty, he deserves a new trial because Becky Hill went above and beyond what she should have done. She wrote a book. And Scott and I both have a copy of that book Because I remember when they said they were taking that book off the market, her co-author was like, yeah, we're pulling this book from the shelves. And I was like, oh, Amazon still has it? I'm buying it just to have in case it's a collector's item. Yep. A jury has been selected in the Colin Gray trial. Colin Gray is the father of Colt Gray, a school shooter in Georgia. And the father is being tried. The openings are scheduled for that trial on Monday. A jury of 8 men and 7 women has been chosen in the trial of Colin Gray, whose son is charged in a Georgia high school mass shooting. Opening statements are scheduled for Monday. His son, Colt Gray, is accused of the September 4th, 2024 Appalachia High School shooting that left 4 people dead and 9 wounded. Colin Gray was arrested shortly after his son's arrest, and he is facing 29 felony counts. Prosecutors say Colin Gray purchased an AR-style rifle as a holiday gift to his son in December 2023. In May of 2023, the FBI allegedly alerted police to online threats about a school shooting reportedly linked to Colt Gray. We saw this in the Crumbly case. Those cases were in Michigan. James and Jennifer Crumbly were both convicted. They were the first parents ever convicted in a U.S. mass school shooting case. Ethan Crumbly, who was 15 at the time, killed 4 students. That was tragic, horrific. That was at Oxford High School in November of 2021. They were both sentenced, those parents, to 10 to 15 years in prison in April of 2024. And I'm not going to be covering that Colin Gray trial, but some of you may be interested in that. Interestingly enough, they did, the trial is going to take place in Hall County. Well, no, I'm sorry. The shooting was in Hall County. So they're taking Hall County jurors, but his actual trial will be held in Barrow County. Okay, forget this. Barrow County is where the shooting took place in Georgia. They are pulling jurors from Hall County. And that is where jury selection is. And that is where the jurors will be taken from Hall County and brought to Barrow County where the shooting took place. And that's where the trial is going to be. Colt Gray was 14 at the time of these horrific crimes. In the Jesse Butler case in Oklahoma, the Stillwater teen who raped at least 2 girls at his high school and was given a sweetheart deal where he wouldn't have to serve any time at all because his dad may or may not have been involved with the Oklahoma State University football program at one time or currently. The judge sentenced him as a youthful offender after he pled no contest, and he was supposed to get 78 years in prison, but instead the judge in that case of Jesse Butler said that he should just get counseling. There's going to be an April 13th hearing on that because one of the victims argued that the ruling violated her civil rights or her rights under Oklahoma's Marsy's Law, which guarantees certain rights for crime victims, and she filed a motion to challenge that sentencing. And so that will be happening April 13th. I'm sure it probably won't be televised, but we'll keep it on the calendar anyway, because we're outraged by that case as well, happening in Oklahoma. Oh, it was frozen. You know why? I know exactly why. Because I can't use the same browser. Okay. All right. Whatever. It's a StreamYard issue. It's my birthday. I'm not going to get pissed about it. All right. Let's go back to the chat. Thanks, Helena. You know, I appreciate you so much. Susan gifted 5 memberships. You're amazing. Thank you. Skybell gifted 2 memberships. You too are amazing. Thank you, Office 39, for your 20. I appreciate you. Office 39 gave me another 20 and said, happy birthday. Once in a while, you get shown the light in the strangest of places if you look at it right. Thank you so much. I appreciate you so much. Tracy Giuliano, thank you for your 20 and your happy birthday wishes. Gypsy Soul Astro Photos says, OMG, she is or was so out of line. I can't believe she's even allowed on a bench with this conduct. Well, there are, judicial rules, and, there are bodies that look over judges, and we'll see if anything happens, but judges do have wide judicial discretion. But the fact, and you're going back to Kelsey Fitzsimmons, the fact that she was removed so quickly, or the Chief Justice acted so quickly, makes me think there's a lot going on behind the scenes that we just don't know about yet. Thank you, Ray, for your 50. You're so sweet. And your birthday wishes. Says, thanks for being the special person you are. I appreciate you so much. Bridget, thanks for gifting 5 memberships because you're amazing. And Fanny Johnson gifted 5 because she's amazing. David Reese said one of the troopers charged was a former professional boxer who fought for a world championship. Oh, well, there you go. I'm not sure which one, but thanks for pointing that out. Venus Blue says, so many Aquarians. My birthday's the 15th. Happy birthday to you too, Venus. Bridget says, you should do a live chat with Boozy Beauty. She's been on this the whole time. Thank you so much for your 10. Appreciate you. Happy 21st birthday, Melanie. Thank you, Nurse Jones. I'll allow it. Jean became a member. Welcome. Beth became a member. Welcome. Thank you, Lawyer's Daughter, for being here for 20 months. Kat Randall, thanks for your 10 and the song. You say it's your birthday. Thank you so much for your Beatles lyrics, which I'll always allow. Lori says, happy birthday. It's your birthday too. Happy birthday, Lori. Have a great day to you too. Thanks for your 5. Amanda, your daughter's birthday is today too, and she's 25. Happy birthday to her. I'm sorry, it's not Amanda. It's Mad. Zoe, thank you very much for your 10. Says happy birthday. You're fantastic in every way. You're the greatest. Oh, and you're a February girl too. Happy birthday to you too, Zoe. Aaron Spencer update. I don't know. Is there an Aaron Spencer update that you're aware of? That is one case I did not prepare for you today. So I don't have anything prepared for you with regard to whether there is. If there is, then you guys can tell me in the chat. Let me know. Let me know. Hang on one second. Oh, well, I have to go like this. See, if I go like this, then I don't freeze, right? Am I frozen now? Am I frozen now? Thank you, Betsy, for your Venmo and your happy birthday wishes. I love you with all of my heart. Thank you, Joanne, for your Cash App and your birthday wishes. I appreciate you so much. Thank you, Suzanne, for your Cash App. $100. What? You're the greatest. Thank you so much. Oh, you're so sweet, Suzanne. Nona to 3. Thank you for your 3 matcha lattes. I will take all of them. I need them. Pamela, thank you for your Venmo. Says happy birthday. Oh, you guys are so sweet. I'm going to go to Sephora. Thank you so much. And I need to get my roots done. 2 of those things can be true. All right, you guys. Oh, well, here's something new. Dun, dun, dun. Hold, please, while I pull up the papers on this. Hold on. This is in the AIDAN KEARNEY, Lindsay Gaetani civil case. Hold, please. Do, 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 do. Nope. Oh, please. mean, it's supposed to be in Superior Court, right? All right. I'm coming at you very soon. And here it is. Cold read. All right, there you go. Hot off the press, as this looks like it was just filed, perhaps today at 10:13 a.m. Breaking news. AIDAN KEARNEY has dismissed his lawsuit against Lindsay Gaetani. Filed with the court today was a stipulation of discontinuance. Well, they call it a stipulation of dismissal with prejudice, which means that AIDAN KEARNEY has voluntarily dismissed or discontinued his lawsuit against Lindsay Gaetani. Here it is, filed this morning, 10:13 a.m., Superior Court, Worcester, with prejudice, meaning he can't sue her again. Now come the parties to it's a stipulation of dismissal with prejudice. Now come the parties to the above captioned matter pursuant to Massachusetts General Civil Procedure Rule 41 and stipulate to the dismissal of all claims brought by the plaintiff AIDAN KEARNEY against the defendant Lindsay Gaetani and all counterclaims brought by Lindsay Gaetani against AIDAN KEARNEY with prejudice, without cost, and with both parties waiving all rights of appeal. There it is. That civil lawsuit is over. The counterclaims asserted in this action by the defendant Lindsay Gaetani against Medfield Police Detective Dylan Haldeman, Massachusetts State Lieutenant Brian Tully, Norfolk District Attorney's Office Special Prosecutor Robert Cosgrove, and Jason Broyles remain pending for independent adjudication by the court. XOXO. AIDAN KEARNEY by his attorney David Heinlein and Lindsay Gaetani pro se. They worked it out. Lindsay's claims against counterclaims against those other defendants may survive. I'm not sure because I don't. Her caption is not on here. I have no idea if he's got to deal with her. I have no idea if they're back together. I have no idea. All I know is I'm reading you a court document. And so he has discontinued his civil case against Lindsay Gaetani. Sometimes it's just better for everyone to just get along. Litigation is exhausting. It's tiring. It will suck the life out of you. And CFIT says, check one off for Turtleboy. That's great. I don't know anything about a lawsuit against anybody. This is a discontinuance of AIDAN KEARNEY's case against Lindsay. And that is all that it is. All that it is. Thank you, Nancy Joe, who says, my sister has cancer and is taking oral chemo. I'm so sorry. With terrible mouth sores, I told her about you with your slippery elm bark. She asked me to tell you, thank you, such relief. Hey, listen, it's throat coat tea. I don't know if it's good for that kind of stuff. I am not a doctor. I will take your 10, Nancy. Thank you very much. But I do not know if that is okay. Please check with her doctor. Please do not. I'm not a doctor. It's for my throat. When my throat gets, when I get hoarse, when I'm reading a lot of documents to you guys, that's what I use it for, not for medicinal purposes. Jomar, thank you, says, happy birthday. My birthday was the 10th. Just didn't mention it. Well, happy birthday to you, Jomar. Appreciate you. And you're an Aquarian too. So happy birthday. Aquariuses unite. Thanks, Jomar, for your 10. Gray Space says, still shook about the complaint against ACPO January. Well, we don't even know what it contains or whether it's going to be swiftly granted. Don't be shook about it because we don't even have the contents of it, so we don't know anything about it. Stand with Mel. Sorry if this has been addressed, but did I read that McCarthy Neyman is retiring? I don't know. I didn't address that at all. That is not anything that I addressed today. So I don't know. There's been lately a couple of judges that we have spoken about that have announced their retirements, and I don't remember if she was one of them, to be honest, so I don't want to give you the wrong info. But thanks for becoming a new member. Thanks, Mel. Thank you, Robert, for your Venmo, who says, happy birthday. Thank you to Roberta. Thank you so much for your Venmo. You guys are super generous today. I love you with all of my heart. Roberta sent 2, actually. Giving me an idea for, I think, a new case. Thank you so much. I'm spread a little thin right now. Paula, thank you very much for your $50 Venmo. That is so sweet of you. I appreciate you so much. I think Betsy, I thanked. Pamela, I thanked. And you guys are amazing. Sarah, thank you from last night. And thank you for your affirmations. And Joanne, thank you so very much for your Cash App. All right, you guys, I'm going to jump. I have plans. So I want to thank each and every one of you for coming to spend 2.5 hours of your day with me. It means a lot to me. And I love you. I love you very much. Zoe said, I looked up Georgia state court holiday schedule to check if Monday is a holiday. This is what the website says. Washington's birthday, February 16th, observed on Thursday, December 24th. Interesting. Well, maybe because they want to make their Christmas holiday a little bit longer. Is that possible? So you mean they do have court on Monday? Okay. As far as speculating about other people's relationships and asking questions in the chat about whether this person has children, whether that person has children, we don't do that. We don't do that. That's why your comments are deleted. If you need to know, we don't dox people. We don't talk about people's personal business because it's not our business to talk about. Quite honestly, if you ask me, it's not our business to talk about, and I'm sticking to it. All right, you guys, I love you with all my heart. I will see you tomorrow morning at 9 a.m. for the Edrick Faust trial. And if you're not watching it, you absolutely 100% should. I love you with all my heart. Thank you, moderators, for doing this for me as often as you do. At the drop of a hat, oftentimes, which is today was one of those days, and I could never, ever, ever do this without you. Thank you so much, everyone, for your wishes and for making my birthday an amazing day. And I love you with all my heart. I will see you tomorrow morning. Come back. Make sure you subscribe. Make sure you hit the like button. Make sure you do all the nice things. Comment after the stream is over. It's a nice thing to do, and it helps the algorithm. All right, you guys, peace out. I will see you tomorrow morning, and have a great rest of your evening. Peace. Oh, this outro that I have here, Lady Zelda made this for me, and I love it. Check it out. It's like supposed to be someone who, maybe kind of looks like me in a cartoon form, but walking out of the Buffs Stadium, and I think it's got the New York skyline in the background. All right, you guys, love you. Oh, wait, should I show you one more thing? I wanted to show you the video that Toy made. Hold on, one more thing. The cupcake yacht video. Did you guys see that? Hold on, because it's so cute. And I want to give Toy a nice little shout out. I can't use it as my outro because I don't have like the raw footage for it, but just hang on 1 second, because if you haven't seen this, you're gonna like the Cupcake Yacht Club, I think. Get on over there and follow Toy, T-O-I, on the tubes of you. Hold on 1 second while I put this up for you. It's really cute. And then we will wrap from there. Okay? Love you guys. Yacht today, Satan. Yacht today.
Ahoy! Welcome to the SS Cupcake Yacht Club. All aboard! SS Cupcake, steady vibes on love already. Floating honest on sea so sweet. Smooth and clean, I don't know what I mean. We're cruising. Gotta trust. Yeah. Say it loud, make it chatty, yeah. Galley crew, we I love you. Today, Satan, oh no, yeah. No. Overruled. Keep it moving. If not, there's a special spot for you. Black Island. Already had a speedy ride for you on the SS ship of fools. Bye-bye. Get it? Get it? Hey,